for
Extension
inclusion
of
in
interim order, Lordship. Now, pursuant to that, your Lordship was pleased to direct the matter to appear after 2 weeks. Accordingly, record has come into this court, Lordship, as I was informed by my clerk, Lordship. Still then, Lordship, it is not
Have you
appearing.
ascertained
Lordship,
that
Lordship,
the record has come?
Lordship,
Then give the slip, it will appear within 2 days.
grateful, Lordship.
My lord, may I have lord slip to mention item number 148, which is appearing in your lordship list today.
Yes.
My lord, on Monday I mentioned, my lord, 3 matters for upgradation, and my prayer is allowed. My lord, 2 matters.
Was any date fixed?
No, my lord, it is your lordship says it will appear as to be mentioned.
Okay, Monday let it appear as to be mentioned.
Yes.
Monday to be mentioned.
My lord, may I be permitted to mention one of the case in which LCR has come and paper book is also ready. So it should be in the to be mentioned list. It was already there, Your Honor.
The respondent has entered appearance.
Yes, Your Honor. I have served the paper book to other side also.
Lord, you need to mention 4 motor accident claim case for condonation of delay application, my lord.
It will appear under the heading application if the records are here.
Lordship, may I permit mention, Lordship, item number 161, hearing matter, Lordship, kindly, this is a matter is a minor day. Lordship, 163, a very short matter. So, Lordship, kindly fix the any day. Very short matter,
Okay, Monday let it appear as to be mentioned.
Lordship.
Lordship, may I be permitted to mention?
Is that the 161?
Give the slip also. You
Lordship, may I be permitted to mention an application for inclusion?
application for
Lordship, it's a stay application in a second appeal.
stay application.
Lordship,
Second appeal.
second appeal.
Yes.
Wait, Lordship.
Time for the petitioner, Lordship. Kindly fix the date of hearing, Lordship.
So the matter is ready for hearing.
Lordship.
Paper books have been filed.
Lordship.
The respondents have entered appearance.
Lordship.
Yes, record an order. Learned advocate for the appellant is present. As this appeal is ready for hearing and the paper books filed, let this matter appear for hearing on 14/5. Time 10:30. 14/5/2026 at 10:30 AM. Item 10. Yes, not today.
I am appealing for the appellant. On 23rd February, your lordship fixed the matter on 18th of March, but on that day, your lordship was in the circuit bench. That is why it was not taken up.
Was this matter hard?
No, matter was appeared as to be mentioned on 23rd of February.
Date fixed 16th of May.
18th March.
16th of March.
18th March.
Yes,
But the
record
lordship was there in the circuit bench on that date.
learned advocate or the appellant is present. As this matter was fixed earlier but could not be taken up, let this matter appear on 14/5/2026 at 2 PM. Yes, not today.
My lord, in this case, my lord has already passed the order with a direction to retrial by the lower court. But the case record had destroyed.
The case record came here.
Case record had destroyed. Lower court record had destroyed due to fire. Alipur, 13th additional district judge, on 14th July 2020. All the records of that court have destroyed. So, my humble prayer before your lordship to send this record to the lower court.
The trial court record which is here.
Trial court record, no. This record is required because
This record means which record?
the record, higher court record, FMA.
No,
T20
high court records cannot be sent to trial courts.
Without record, we can.
You have to reconstruct. You have to file your certified copies there. You collect certified copies from here, or you prepare. There was a paper book.
Paper book.
On that basis, let the order records be reconstructed. Make a prayer before the learned court so that the prayer for reconstruction is allowed. Okay. Yes, record an order.
My lord, this order may be
Yes.
certified. I applied, right?
Learned advocates for the appellant is present. It is submitted by the learned advocate that the trial court records were destroyed by fire in the year 2020.
14
Stop.
July 20.
Thus, the appellant, who was the claimant in the motor accident claim case in the trial court, is permitted to make necessary application for reconstruction of the record, which is to be considered by the learned trial court for reconstruction. Stop. Upon reconstruction of the record, the matter to be heard out.
A certified copy may be given to me.
Yes, urgent
If I
certified
applied.
copy. Urgent certified copy. Whatever it is, you have the copies, you just pray for reconstruction of the records, and that will be
So
considered.
copy of the order may be sent to the.
This order.
This order. This
Yes.
order along with the earlier order.
No, you apply the
2/2/26 order.
Yeah. The copy
Order
of this
dated-
order as well as order dated
2/2/26.
2/2/26 be communicated to the learned trial court.
16 lawsuit, I am opinion of the appellant lawsuit. Lawsuit appeal already ready, and also ex parte hearing was started. 2 days was heard this matter. Thereafter lawsuit Honorable Justice Bivas Ranjan De due to superannuation matter was not concluded lawsuit.
So both sides have not appeared in this
That
matter.
was ex parte.
The matter was heard ex parte.
The lawsuit. Kindly see the last 2 order lawsuit. It is Joseph.
Order to the
Lawsuit first order 3rd 10 to 2024.
No,
We-
this was admission, order of admission.
No, that was the ready for hearing.
3/10/2024 matter was-
Ready for hearing. Next lawsuit 21st March 2025.
So actually, in this matter, none
Heard the council appearing on behalf of the-
none represented the respondent.
Yes. The next order lawsuit, kindly see 26 2025 also.
How many respondents are there? 80.
So many respondents.
None of the respondents appeared.
Both the court ex parte. Trial court ex parte, appeal court also ex parte.
So both courts held against you.
Yes, lawsuit.
Yes, learned advocate for the appellant is present. As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing 15/5/2026 at time tab dekun at 2 p.m. It's not today. Yes, not today.
Well, the point involved is the application of multiplier.
Yes.
Application of multiplier only.
Which application?
Application of multiplier, well, the point involved.
My lord, this appeal is on quantum, my lord. Various points are there, my lord. Various issues are there, only on quantum.
The case of my lord, the application, my lord.
166.
Yes.
Other accident 2009. Other
Yes, record and order. Learned advocates for the parties are present. Was this matter fixed earlier?
yes. Can act was a fine.
No. Was this matter fixed, specially fixed earlier?
खाली पैसा पाइनी पैसा
Learned advocates for the parties are present.
जज साहब जाई देखिए सर
The-
पैसा पाइनी
So I have.
As the paper books have been filed and the matter is ready for hearing, let it appear for hearing on 15/5/2026 at 10:30 a.m.
Not sure.
Not today.
Number 25, I am for the respondent. In this case, already LCR has come and matter is ready for hearing.
Paper books filed.
Paper book file already and LCR. Oh, in this case, whatever my lord, in this case, it was dismissed for default. So that's why the LCR was sent already in the lower court.
So thereafter it is called back.
Yes, my lord. No, LCR has not been called.
আচ্ছা, record and order.
LCR তো চলে গেছে।
তারপর learned advocates for the parties are present. As the TCR was sent back to the learned trial court by earlier order dated. Yes, when
When it was sent back.
it was dismissed.
It was dismissed on, my lord, 24/10/2025.
On 24/10/2025, when the appeal was dismissed
For default.
the said records are necessary as the appeal has been restored. Stop. Thus, the trial court records be called for at the special messenger cost to be put in by the appellant within 1 week.
My lord, respondent, I will pay the special.
Acha, special messenger cost to be paid by the respondent within 1 week. Liberty to mention after 3 weeks. So paper books are already filed.
Paper books are already
Okay. So liberty to mention after 3 weeks.
ও বলছে
My lord, this matter appear on my lord 28. My lord, when my lord, I submitted before your lordship, my client has filed a court along with an application. Your lordship, on the basis of my office copy, your lordship allowed the delay petition.
Which application was allowed?
Application for condonation of delay.
So that was allowed.
Is my lord dictated, but subsequently, since the application was not in the file, your lordship recall the order and place it to court with the application.
Now the application is appearing in the list.
Application.
What is that application? Can 2. There are 2 can 1. One is by the appellant and the one is by the objector.
There is a delay of 54 days.
No, can 1 of 2025. That is FMA 752. That is your application.
That is stay application, one stay application.
No.
This is stay application.
Yes, quarter,
Okay.
quarter 125. October
So that is already allowed.
Yes, madam. Yes. Already allowed.
Okay, that is already allowed. Now, today, this can 1 of 2025 passed by the respondent cross objector has to be taken up.
Court 125 of 2005.
Court 125.
125.
But his application is can 1.
Delay of 54 days.
Yes, record and order. Learned advocates for the parties are present. The application for condonation of delay filed in court 125 of 2025 by the claimants cross objectors is taken up for consideration by consent of the parties. Heard learned advocates peruse the petition filed. Upon hearing the learned advocates and upon perusing the petition filed, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring the cross objection COT 125 of 2025 is condoned and the cross objections is admitted.
Paper book file, it was earlier occasion appearing to be mentioned for fixation of a date.
Paper books have been filed, both.
Paper book file.
All documents incorporated?
All documents. All documents.
Both court and this one.
Yes.
Yes, as the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing on 18/5/2026 at 10:30 a.m.
25 May.
18th of May.
18.
My lord, I am for the appellant in this case, and the matter is ready for hearing. I am serving the paperwork also, my lord. From last 1 year, it is pending, my lord. It's a case of 2019.
Anyway, this is a case of 2025.
The incident happened in 2019. The appeal was filed in 24, but the incident is of 2019, my lord.
Anyway, you can wait up till vacation. Let me keep it after vacation.
No, one date should be fixed, Your Honor.
Yes, yes, record an order. Learned advocates for the appellant is present. Yes, respondent has entered appearance.
Respondent from last 1 year, no one is appearing, my lord.
It's better. You serve one copy. Learned advocate for the appellant is present. None appears for the respondent in spite of service of notice. I'll just mention the name of the advocate. However, this court requests learned advocate who appears for Railway Authority to take necessary instruction and appear in this matter. Let a copy of the paper books be served upon the said learned advocate.
On last
I'm
occasion,
keeping it on the reopening date after vacation.
On last occasion, my lord has appointed Chandri Alam as.
Then it's okay.
No, not in this case. In the another case.
Let me see either Mrs. Alam or some other learned advocate.
After vacation, date should be fixed, my lord.
Yes. Let this matter. Namta blank rakun ami pore eta dekhe nichi. Let this matter appear on 8/6/2026. Reopening date after vacation.
Time should be mentioned. 10:30, 12.
Okay, 9/6/2026 at 10:30 a.m.
29, my lord. 29, my lord. 29 and 30. Date may kindly be fixed for hearing.
29 and 30. Learned advocates for the parties are present. As this appeal is ready for hearing and the paper books filed.
After summer vacation.
Yes, what is this application? Can 1? Condoning. Can 1 is whose application? COT? COT is yours.
What is yes, my lord?
So whose application is this Can 1?
This Can 1 is, my lord, is for incorporating an additional ground in the court.
So is it a part of the paper book?
Court has already been, paper book has been filed.
Can application?
This cannot, no, paper book is no.
As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing. Bolun to kobe? 18/5/2026 at 12 p.m. Okay.
I am for the appellant.
My lord, I am for the respondent. My lord, it is a point. My lord, involved by the question of driving license. My lord, tribunal was passed. My lord, the insurance company satisfied the hour. And my lord,
Before the tribunal, it was.
So insurance company has satisfied the award. Only the point of challenge is recovery.
Yes. This is a case under section 166 of the NB Act.
One?
Amendment of the 1919.
Yes.
And in the same section 150, subsection 2 of the said Act, my lord, there is no provision to recover the amount from the owner of the vehicle.
Anyway, different on the
In this case,
decisions of the Supreme Court.
Accident? No.
Decisions of the
Till
Supreme
date-
Court, pay and
till-
recovery is granted.
Till date, my lord, this is an accident taken on February.
What is the order passed by the tribunal? Pay and recover.
Pay and recover.
So what is the wrong in this order? Anyway, I shall consider that. Let this matter appear. Yes, learned advocates for the
my lord, my lord, one time pay and recover, my lord.
learned advocates for the parties
Pay and recover.
are present. As this matter is ready for hearing and the paper books filed, let this matter appear for hearing
My lord, after vacation.
Oh, what after vacation?
9/6/2026.
9/6, my lord, is only pay.
So you have
9/5.
received your compensation amount.
Yeah,
But
no.
You are the vehicle owner.
No, I am the claimant, my lord.
So there is a direction of pay and recovery.
There is no payment. Insurance company prefer the appeal.
Very well, very well. Now the question is, the insurance company has secured the amount.
Yes.
No, it's already secured.
If insurance company has secured
The
that
only
amount.
point pay and recover.
So only point.
Only point.
Your learned friend is your learned friend is asking
Learned friend is quite
asking for 9.
The point involved in this case, my lord is presently hearing these motor accident claim cases, which are under Motor Vehicles Act 1988. Under Motor Vehicle Act 1988, Section 147 and 149, there is a proviso of pay and recover. Supreme Court is granting this pay and recovery order as just now fallen from your lordship, because there is a provision in the statute itself. Starting from Swaran Singh and Baljit Kaur, that advantage has been taken by the Supreme Court that when insurance company makes any payment over and above its insurance coverage, then it has the right to recover the same from the owner of the vehicle. That is there in the statute. So on that basis, when insurance company pays any money which is over and above the insurance coverage, then the right to recovery is granted. Your lordship knows, in 2019, effective from 2022, Act has been amended. In that amendment act, this provision of right to recover, which was there in the 1988 Act, has been obliterated. It has been removed. So, once this right to recover has been removed from the statute itself, insurance company, today in this particular case, since the accident took place after the amendment of 2022, pleads before your lordship, that since the right to recovery is not any further in the statute itself, so, this cannot be fastened upon the insurance company to pay and recover. The amount should be paid by the owner directly. This is the point of law. Your lordship has to decide. No other, Supreme Court has not come out clean on this as yet, that whether the right to recovery under the new act, after the amendment, if the accident takes place, if there is any, then whether the right to recovery can be granted or not. So, this point, my lord has to hear.
Anyway, that point has to be considered.
Lordship.
My lord, your lordship, kindly hear me.
I will hear you when the matter will be fixed for hearing.
Before
Let this
vacation.
matter appear on 9/6/2026 at
9/6, if the bench might be changed,
very well. The other bench will be available.
Earlier occasion, a matter was fixed as for order.
No.
Some
Madam,
bench
my
will be
client-
available. For some days, few days, you will not suffer any loss.
9/6, my lord.
9th of June, okay?
To that extent, whether I will be survived or not, I don't know. Because coming ensuing election.
9/6/2026. That is
My lord, 9/6, my lord.
at
there
12
is a-
p.m.
My lord, there is some difficulty because my son are not there, my lord.
I will not survive, my son.
My lord, before that, my lord, any day, my lord, on 28th, 15th, 18th, 16th, my lord, 5 minutes. My lord, 20.
আচ্ছা দেখুন তো এই 20-21 ইয়ে আছে কিনা শেষের দিকে মে মাসে 20-21 ওই শেষের দিকটা একটু ওকে 20th of May 2026 at 3 p.m. 20
I'm grateful. খুশি তো? আসছো?
সেখানে আমি আসবো না।
He said he will not.
Very well. Expertise. Okay, if you so please. In all the matters, you are not asking expertise. If this is a special case,
Not one asking, never asking.
So if this is a very special case that you are asking expert, it will be taken up.
32 is my appeal, my lord. It's only on the point of consortium. My lord remembers that parental.
Oh,
My
I
lord,
think I've heard this matter.
yes. My lord asked me to get the judgment of my lord, wherein my lord has dealt with this. This is the judgment. Only parental.
This is a consortium.
Consortium.
Or parental consortium.
Both
Filial consortium.
filial and parental both were granted, so I have preferred the appeal. And in this judgment, my lord has dealt.
So the ground of your challenge.
Yes.
Okay. Was this consortium and the any other issue with regard to quantum?
No, he has probably interest.
Court.
Regarding
Interest.
How much is granted?
My lord,
He wants it from it should be from the date of filing. It was from 1/1/2020. Date of filing is sometime in 19. He will provide the date.
my lord, application filed on 9th January 2019.
So it should be
And
from the date from that date.
Tribunal granted interest from the date of 1st January 2020. After 1 year. My humble request, sir, humble submission, because only 1 year.
And in the
Interest of
day before yesterday also, my lord had granted that parental consortium. My lord, I leave it to my lord. My lord will kindly. I'm sorry, filial consortium.
Ground of challenge is both filial as wife's consortium
Yes,
is there.
yes.
So filial consortium is granted.
Yes. I was. It just slipped my.
Claimant.
There's widow, mother, and minor daughter.
Mother
and minor daughter.
Three claimants there, my lord.
In this matter, paper book was filed.
Yes. Everything. My lord had heard it.
দুটো আছে, পেপার 2 ভলিউম 2টা দেবেন, ভলিউম 2
দুটো ভলিউম আছে।
বাবা দেখি
নাহলে আমারটা নিয়ে নিন, না থাকলে। আচ্ছা,
ভলিউম 2
Volume 2, page 231, my lord, the relevant portion of the award. Third paragraph, page 231.
Volume 2,
page 231. That is regarding the consortium. Starts at page 231. The relevant portion is paragraph number 52. That is the very next page, 232.
Paragraph number.
এটা হয়ে গেল আর কি, এটা হয়ে গেল 21/20 ওইটাই রেকর্ডটা পাঠিয়ে দাও, সেন্ড ডাউন করে দাও এখানে, আজকে করে দাও। ও কালকে করে দিও, 1736টা একটু
So 48,000 was granted to the child also. No, you are objecting both to the mother as well as the child. That is
yes.
96,000.
Except spousal consortium, I am objecting to all consortium, but I leave it to my lord. My lord will not record my consent.
No. Your ground of appeal is
Yes.
consortium to
Yes.
put this
Yes.
as well as overall compensation.
No, overall it's okay.
Only 48.
Yes. I dispute that 96,000. 48 and 48. And in my lord's judgment, page 21 is the relevant portion.
Dealt with Nanuram and the division bench.
Yes, my lord. This was the judgment my lord was referring to. On the last date, I could not.
Page 19.
21.
Of course, there is also another thing that is with regard to unmarried child, but here it is a married child also.
In this instant case, the one.
It's a married
Minor
child,
child.
but that
It's
was
a minor daughter.
In here,
a minor.
in my case,
Minor.
No. So far, the mother is concerned.
My lord.
This child is a married child, but you see, filial consortium, so far this Nanuram and my judgment, it dealt with some unmarried child.
Yes, minor. That was a minor. In this case also, it's a minor. In this case.
Victim.
4 years. No, my lord.
No, the victim was he was aged 38 years. Major.
Yes, but he
I understand.
was-
My lord. But my lord has more or less given a number of judgments. My lord had already decided the issue of consortium. As I was saying,
consortium, actually, if I follow this,
yes.
then only unmarried. If the victim is an unmarried child, if I follow my own judgment. Yes, record and order.
Well, in this regard, I have also filed 2 citations from this. On earlier date, I am filing.
नामटा बोले दिन ना.
Well, one of these, 2025, volume 4.
Manjula.
No, yes, Manjula and others.
Which paragraph?
And last one, 2024, volume 4, TAC, page 32, Supreme Court. Rahila Khan. Paragraph 6, page number 3.
Paragraph
6. One of the Manjula. Manjula's matter.
7.
Paragraph 6, page number 3.
Page 33.
Page number only 30, only 3, my lord.
Rahila Khan.
Rahila Khan. Oh, Rahila Khan. Later. Yes, my lord. Rahila Khan is page 33, para number 7. Loss of spousal consortium and loss of parental.
Which paragraph the Honorable Supreme Court has considered? Pranay Shetty. Yes, with order.
Paragraph number 7.
Paragraph 6 with regard to the
consortium?
With regard to regular employment.
Yes. The children and parents also are liable, entitled to, at the rate of rupees 40,000 each. The award hence shall be as per tribulated list.
Okay.
This.
Learned advocates. Yes.
Regarding my court.
Yes.
My court.
Yes.
As per section 171 of the Motor Vehicle Act, interest should be imposed
from the date of filing of the claim case.
Yes.
And here it is not granted.
After 1 year. Only 1 year for my service.
How much percentage of interest awarded?
6.
Learned advocates for the parties are present. Hard learned advocates. The appellant in this appeal was an opposite party insurance company in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the quantum of compensation and is aggrieved by the judgment and award dated
20th of March 2025.
20th of March 2020.
2025.
Judgment and award dated.
Volume 2, page number 211.
Judgment and award dated 20th March 2025. Stop. The appellant insurance company, being aggrieved by the quantum of compensation, has come up with the instant appeal. Stop. The claimants, respondents number 1 to 3, being also aggrieved by the quantum of compensation, has come up with the, has filed a cross objection, being COT number 108 of 2025. Stop. By judgment and award dated 20th March 2025, the learned Judge Bench 4, City Civil Court, Calcutta, was pleased to dispose of MAC case number 25 of 2019 by observing and directing as follows. Set out. এই পাতাটা একটু set out করে দেবেন। Page 234, হ্যাঁ, এখান থেকে। এখান থেকে এই অবধি হোল্ড করে দিচ্ছি, এই যে এই অবধি। The both appellant insurance company and the claimants respondents have filed appeal and cross objection, being aggrieved by the judgment and award passed by the learned trial court. Third learned advocate for the appellant insurance company and learned advocate for respondent number 1 to 3 claimants peruse the materials on record. Learned advocate for the appellant submits that the learned trial judge erred in awarding consortium to both mother and child of the victim, which is against the decision of the Honorable Supreme Court in the case of National Insurance Company Limited versus Pronoy Shetty, reported in AIR 1917 Supreme Court, page 5157. Learned advocate also relies upon a decision of this court in FMA 283 of 2025. Stop. Learned advocate for the respondent number 1 to 3 claimants submits that the learned trial judge did not commit any error in awarding compensation to the mother and child of the victim. Stop. Learned advocate relies upon the following judicial decision. Rahila Khan and others versus Naushad Ahmad and others, reported in 2024 within bracket 4, TAC 32 within bracket SC. Page, ঠিক আছে। Second হলো Simoti Monjula and others versus branch manager Oriental Insurance Company Limited and others, reported in 2025 within bracket 4 TSC 1 SC. Stop. Upon considering the decision of the Honorable Supreme Court in the case of Pranay Shetty, Air National Insurance Company Limited versus Pranay Shetty, the 7 judges bench. Pranay Shetty was 7 judges, 5 judges bench of Honorable Supreme Court decided the issue of consortium. It was expressly decided that parental care, which also amounts to parental consortium to the child, cannot be granted. Stop. Thus, this decision is binding upon this court. Although, with regard to filial consortium, there was no specific observation. This court, in the earlier decision, in the case of United India Insurance Company Limited versus Kalpana Baske and others, in FMA 283 of 2025, considering the decision of Nanu Ram awarded filial consortium. Stop. Thus, this court is of the view that consortium granted to the child of the victim cannot be sustained. Stop. With regard to the submission of the learned advocate for the claimant respondent number 1, 2, and 1 to 3, that compensation was awarded, the interest on the compensation was not awarded from the date of filing. This court is of the view that such submission has some substance as per section 171 of the Motor Vehicles Act 1988. In the facts and circumstances, this appeal stands disposed. This appeal, FMA 1131 of 2025, along with COT number 108 of 2025, stands disposed. The judgment and award passed by learned Judge Bench 4, City Civil Court, Calcutta, in MSC case number
25 of 19.
25 of 19 on 20th of January 2000.
March.
20th of March 2025 stands modified to the extent that the respondent number 1, 2, and 3 will be entitled to a compensation of rupees
5948006.
5948006, along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Stop.
48 কমেছে আচ্ছা আচ্ছা তাহলে ঠিক আছে তুমি করে নিয়েছো ঠিক আছে
The appellant insurance company shall deposit rupees 59,48,006 along with interest at the rate of 6% per annum from the date of filing claim case till today,
that is
before the Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. In the event the amount awarded by the learned trial court is already deposited, no further deposit to be made.
I believe we have to, because that 1 year interest he will be getting.
Well, kindly
In the event there is any
Shortfall,
deficit,
my lord.
there is any deficit of the amount which is already deposited before the learned trial court, the balance amount be deposited within 8 weeks. I think it's
Yes,
clear.
yes.
Well, kindly note this date of filing of the claim application 9th January 2019.
Oh, it is not necessary.
That will be better for calculating. তোমাদের ক্যালকুলেশন
Date of filing of the claim case করে দেবেন।
Date of filing the claim
Department
application?
letter এ যেটা আছে না ওখানে, from the date of filing of the claim case, that is
09012019. 0901
0901
2019.
2019. So if there is any deficit,
My
they
lord.
go to deposit, balance amount be
Yes.
deposited.
Yes.
The respondent number 1, 2, and 3 are permitted to withdraw the compensation amount upon compliance of necessary formalities.
I'm grateful, my lord.
Grateful.
Deeply obliged.
এইটা দিয়ে দিন এইটা। Yes, 34, 35, not today.
বললো 20 বললো না 20 মে না 28
0901 মানে 9 জানুয়ারি 2019। 20 মার্চ, হ্যাঁ 20 মার্চ 2023।
Yes, who is for the appellant?
Mr. Shomallo Ganguly. He was there, my lord. He's coming now. And my lord, I am appearing for the claimants respondents in this matter. The award has been challenged by the insurance company before this honorable court on the ground that, on sole ground, that the vehicle number written in the first information report was another and the different is appearing in the charge sheet. That is the sole ground. Very short point, my lord. So, what is that? তাহলে আমি start করব? আচ্ছা, ঠিক আছে। My lord, let me start, my lord. He's coming.
So what is your ground for cross objection?
My ground is, my lord, the deceased, my lord, after the accident was hospitalized for few days. And my lord, after 3-4 hospitals, my lord, he spent 2,91,291 in Medica Hospital, Kolkata. My lord, one representative was went to the tribunal and deposed to that effect and proved all the documents and medical bills. In spite of that, Lanet Tribunal didn't consider the medical expenses along with the compensation. This is my lord, my ground. Second ground is general damages, my lord, granted. 16,500 loss of estate, 16,500 funeral expenses, and filial consortium 44,000 to mother only and not granted to father. Even, my lord, the father was totally exonerated to pay any compensation.
Yes, father was
Not considered to receive any compensation. Only mother. Even in that case, father, if the father was the claimant before the tribunal,
father was the claimant.
Was the claimant from the very day one, my lord. He was not considered to receive any amount on account of filial consortium. And my lord, interest granted at the rate of 6% per annum. And my lord, general damages, my lord, 6 years and more, my lord, elapsed. So 20%. So Lanet Tribunal granted only 10%.
Oh, that is sufficient.
So, my
That
lord,
is
I am not on that. And my lord, the income,
So your ground of challenge is what?
only this.
Only
this, my lord. The filial consortium not granted to further medical expenses of about rupees 2,91,291, which is fully proved with documents by person concerned. But even in spite of that, my lord, the learned tribunal didn't consider for 1 rupee also. And my lord, the income, has been considered appropriately. Even my lord, they are not on the point of income, only they are on the point of vehicle. Vehicle number not tallying with FIR to charge sheet. That is the ground, my lord. They have not taken any steps in the tribunal, my lord. Though they have produced 4 witnesses. The investigation officer also came on their behalf.
the opposite parties.
Opposite party insurance company. They took leave under 170 of the Act and taken the burden to prove all these in absence of the owner. Even, my lord, they have failed to discharge their liability before the learned tribunal. So learned tribunal rejected their plea and, my lord, granted compensation to the claimants. My lord, may I start for on behalf of my learned friend? Then your lordship, may I?
No. Question is, you have submitted your case
My lord.
regarding the quantum.
Yes.
Filial consortium to the
Quantum, my lord, absolutely.
no consortium to the father. That is your ground of challenge. So I have to hear the appellant now.
Yes, my lord. My lord, income, my lord, regarding income part. So he was, my lord, on farm. It was proved by the employee case.
Your case is you are challenging non-grant of filial consortium to the father and the medical expenses.
Which is proved, my lord.
So these are the 2 grounds of challenge.
the 2 grounds.
Anyway, that will be considered from the
My lord,
record.
income has been taken, my lord, rightly. 18,000 less
Profession tax and income tax.
deducted rupees 130. So it's come 7,870. It's applied multiplied 17, my lord, since the age was 26 and 27 in between that. And my lord, 50% deduction since, my lord, the parents are the claimants.
Okay, this matter is not appearing. Hey,
My cross objection is wrongly, my lord, appearing another matter, my lord, number is
তো অন্য নাম্বার অ্যাপিয়ার করছে আর কি
it is, my lord, in the file, my lord, my cross objection is there.
আমার অন্য সাথে কস্ট টাইটেলটা তো আলাদা হয়ে গেছে
কিন্তু ফাইলটা ঠিক আছে নাম্বারটা 574 আছে বাট 500
My case number 547.
তাই জন্য যেহেতু কস্ট মানে নাম্বারটা ভুল আছে সেহেতু এই নাম্বার মানে কস্ট টাইটেলটা ভুল এসে গেছে
Otherwise, my lord, it's okay on consent of the parties, my lord, finally dispose of the matter. So, my lord, may I place the claim application first?
No, question is, you see,
Yes,
let us consider their ground of challenge.
yes, my lord, I will come on that. I will come. I will take 160. Should I place, my lord, the papers one by one?
Yes.
Your lordship kindly come to page 1. That is the, my lord, claim application filed by the claimants with the learned tribunal after the death of their son. So go to P1. My lord, claim application they disclosed the age about the son was aged about 27 years at the time of incident. And my lord, he was under the occupation of resident engineer of Vision Age Solution located at BRB NML Shalboni for technical support for the allocated project. Next page, my lord, thereafter, the name and address of the employer, the general manager, Bharatiya Reserve Bank Note Mutram Private Limited at Shalboni and Services. Managing Director, Vision Age Solution. Under this employer, my lord, he was doing his duty. The gross salary has been disclosed as rupees 18,000 per month. My lord, it was ultimately proved by the employer concerned. Subsequently, in the trial. My lord, thereafter, my lord, page 3, serial number 10. The victim deceased was a rider of non-offending motorcycle. He was riding this vehicle this is not relevant. Thereafter, next page, page 30, serial number 30, page 4. The deceased victim was firstly treated at Kalboni Rural Hospital on 13/12/19 and thereafter treated at Midnapur Medical College and Hospital and thereafter at Medica Super Specialty Hospital at Kolkata, where he died on 20 December 2019. So accident happened on 13th. He died on 28th. Malad 8 days. He was in hospital and was treated. And my lord, here my lord, rupees 3,50,000 was claimed as medical expenses, and mother and father was the claimant 35 lakhs, and along with my lord 3,50,000 as medical expenses was claimed. I'm coming on the written statement letter. She will place my lord his written statement. Thereafter, lordship kindly come. Page 16. This is the evidence of mother of the deceased. See that we have prayed for compensation in this case due to accidental death of my son, which occurred on 13/12/2019 and died on 20th/12/2019. That on 13/12/2019 at about 6 p.m. was near Mundol Kupi Kali Mandir in the extreme left side of NH 60 under PH Shalbani, Paschim Medinipur, while my son, that is victim deceased, Sogato Tiwari, was returning home from office by riding motorcycle being numbered at that time the offending vehicle, that is one tractor bearing number WP16AZ 7790 was operating with excessive high speed, endangering human life and safety for others that can about any horn gas the victim deceased his motorcycle from behind. As a result, the victim was thrown away from the non-offending motorcycle and fell down on the road and sustained grievous injuries all over his person. Immediately after the accident, my said son was brought to nearby Shalbani Rural Hospital, and therefrom he was taken to the hospital, and thereafter he was shifted to Medica Super Specialty Hospital at Kolkata, where he died on 20th December 2019. That the accident took place solely due to rash and driving of the driver of the offending vehicle bearing number WP16AZ7790 tractor. It was targeting the driver of the offending tractor, and after investigation, that my son was and my son was the sole breadwinner of the family, and he was active, sincere, and good health, and was an efficient and he had a bright future. That my deceased son was resident engineer of Vision Age Solutions located at BRBNML Kalboni, and he used to earn rupees 18,000 per month and used to contribute the same in our salary hours, and we the petitioners were totally dependent on him. But due to the sudden prematurity, have to into great difficulties and hardship and into starvation and span of my life of our family members is 75 years. That we have not taken 500 in case under 140, we have paid 38 lakhs 56. This is that evidence under the cross. I mean, এটা শেষ করে দিই তো cross examination. They say witness without one. Whether she produced some documents here exhibited. Thereafter, that this was my son. He was bachelor is my hostel. We all reside under the same Vastu. Saurabh Tiwari is my younger son. Saurabh accompanied the deceased to Medica Hospital, Kolkata. Saurabh studied after MSc BA. The deceased was first admitted at MMCA, Medical College and Hospital. I have not found any other documents to show that the deceased was treated first at MMCA. The people used to travel by his motorcycle wherever he went outside. The road on which accident occurred is lying from Kolkata towards Calcutta. The road is narrow pitch road and I did not witness the
Yes,
accident.
page.
Page, my lord, 90.
Okay.
This is the cross examination.
Okay.
And he, my lord, produced some documents that executed without any objection from the other side. And my lord, he was cross examined by the insurance company to the effect that the deceased was my son, he was bachelor, Subhash Chandra Tiwari is my Vasu, we all reside under the same Vasu. Saurabh Tiwari is my elder son. Saurabh accompanied the deceased to Medical Hospital, Kolkata. Saurabh studied up to CPA. The deceased was first admitted to MMCH. I have not filed any other document to show that the deceased was treated first at MMCH. Midnapur Medical College. The deceased used to travel by his motorcycle. He went outside the road on which accident occurred right from Calcutta towards Shadman. The road is narrow pitch road. I did not witness the accident at the relevant time. The deceased was riding his motorcycle. Said motorcycle is not used by anyone after the accident. The said motorcycle got already damaged in the accident. It is lying in the garage. Not a fact that the group was not 27 years old at the relevant time. My husband is a retired school teacher. Not a fact that the disease was not an instant at Vision Age Solution at BRT NML. Salmoni, not a fact that the disease had a salary of 20,000 per month. Not a fact that the disease was not the sole breadwinner of the family. Not a fact that the disease was negative. Not a fact that it was false. Hereafter, my lord, the page 20, the evidence of Papu Ghosh, he was the eyewitness and my lord, he was the only eyewitness. Okay. That the victim deceased over the theory of this case is known to be as long as he was a man of neighboring village and the stage over the theory died in a motor vehicle accident which occurred on 13/12/19 and I saw the accident with my own eyes. That I am reporting this case on behalf of myself that on 30/12/2019 at about 6 p.m. in the evening, while I stood near Kuti Kalimurti in the extreme left side of an A60 under PS outside. This is was returning home from his office by riding WP 461. At that time, suddenly one tractor was crossing in direction with extremely high speed. Rashly and negligently, that's the victim around with these stage motorcycles. From behind as a result, the victim was thrown away from non-offending motorcycle and fell down on the road. That stage accident took place only due to rash and negligent bearing number WD 68. The condition was clear. He was referred to medical college hospital. Thereafter, he was treated to medical hospital at Kolkata, where he was treated by the doctor as an indoor patient for 2 days and subsequently died on 20th December 2019. That subsequently, I was interrogated by the of Salman PM in efficient engineer of Senate. That the cross examination by the company in this case, that is page 22, next page. I have filed an check from my
এই যে কাগজ দিন কাগজ
and this is very vital. The only eyewitness in this case on the behest of the claimant and my lord, the insurance company not come with any eyewitness though they have disputed the vehicle number in this case. I was interrogated by the police. I have not received any summons from the court. I know the claimants and I knew the deceased as neighbor. The accident occurred near Vandalkuti Kalimurti at the time the deceased was riding cycle. The offending vehicle was coming from the opposite direction at the relevant time and passed the motorcycle of the deceased. The motorcycle got badly damaged in the accident. The offending vehicle remained at the scene after the accident. After 15-20 minutes, the police came and secured the police took both the offending vehicle and taken continuous view is 3 kilometers far from the house of the deceased. The elder brother of the paternal uncle of the deceased also came to investigate narrated the incident to the elder brother of uncle of the deceased. The fact that the deceased was not an installation at PRG Shalguri, not the fact that the deceased was not treated at Shalguri Hospital, MNCH and medical hospital, not the fact that the offending factor was not responsible for the accident, not a fact that the accident occurred due to negligence of the deceased alone, not a fact that the accident was not occurred in the manner stated by me in my chief, not a fact that I was falsely, only this. Thereafter, PW3, page 23. Well, the authorized representative of the Medica Super Specific Hospital.
That is medical bill.
Medical bill. It is proved and exhibited as exhibit 10. Hereafter, my lord, PW4, the employer sent my lord the one representative to prove the pay slips, my lord. It was, my lord, exhibited collectively, exhibit 12 for 3 months, from month of June to 3 sheets, June to October of 2009. And my lord, the OPW1, the insurance company.
OPW2.
OPW1.
OPW1.
Page 26.
Page 26.
This is, my lord, the investigation officer. Will take, okay?
Okay.
But on the behest of the insurance company, they took the leave under section 170 in absence of the owner. My lord, the responsibility taken by them in their shoulder to prove the case, and my lord, they called the witness from the police station who conducted the investigation. Apart from then the SI.
No, OPW1 is, yes.
OPW1, SI.
Investigating officer.
Honorable Mohan Panda. At present, I am attached with Atal PA as SI. I was endorsed with of the case being solvent case number 58 by 19, dated 14 December 2019 under section 229, 37, 38, 304A of IBC. After initially 304A was not there. After the date 304 was added. After investigation, I submitted the charge sheet being charge sheet number such and such, dated 16/2/2020 under section 229, 237, 238, 204A of the IPC against the driver of the offending vehicle bearing number WB 16-7790. During investigation of the complaint, Subhash Chandra Tiwari subsequently filed a detailed information citing the original number of the offending vehicle. Cross-examination.
No, what was the vehicle mentioned in the FIR?
FIR was different but tractor. It was also tractor and this one also tractor.
No, FIR was?
FIR was, my lord. In the FIR, my lord, you will find the number was written as WB 34G8130. It was also tractor.
So FIR named vehicle was?
34G8130.
WB?
34G.
Yes.
8130. It was mentioned in the FIR only.
8130.
Yes, my lord, your losses can be come to.
Yes, then subsequently?
Subsequently, it is the evidence of the officer that during investigation, the complainant Subhash Chandra Tiwari subsequently filed a written intimation citing the original number of the offending vehicle.
I want that. Yellow blue.
Now what happened?
Original number of vehicle.
19 December at the evening, my lord, the accident happened. He was, my lord, in this hospital, and Kolkata hospital
And-
at the.
And he got blind.
Huh?
দেখতে পারেন, চোখে দেখতে পারেন।
And this person was not the eyewitness. Who was the informant?
DFIR maker.
Yes. Yatha Mosai of the disease. And my lord, he was admitted in the hospital, medical hospital the next day, very early morning at 5 a.m. So they spent their whole night in the hospital from Midnapur to Kolkata. And thereafter, my lord, they returned and my lord lost the complaint with the officer in charge within few hours after the admission in Kolkata. Thereafter, my lord, your losses finally come to the last two lines, cross-examination by the claimant. During investigation, it was revealed to me that the actual offending vehicle was WB16 SX.
Okay, that means FIR named vehicle was one, and subsequently during investigation, the IO found that the vehicle is so and so.
7779.
I mean, the IO found from the information given by the claimant.
Okay.
IO didn't found by the investigation.
From the witness.
IO found by the claimant. The claimant has stated that this is the
I think no, subsequently, no, complainant, not claimant, complainant.
Lordship, that will be evident from the charge sheet. In the charge sheet,
How many charge sheet witness are there?
Your Lordship, the charge sheet witness are, Your Lordship,
Well, your lordship kindly come.
page 60.
62. 62.
Only one charge sheeted witness. Only one.
No,
Number of accused person charge sheeted is one.
No, accused person. How many witness are there? 20.
Page 62.
Yes.
No, 60 to 20.
Serial number 14. My lord, they are cited as 20 witnesses. Your lordships kindly come to serial number 14-8. 8 Papu Ghosh, who was cited as witness.
14.
14. And my
No, 14?
Serial number 8.
8 page 60.
Under 14.
Yes.
Papu Ghosh. He was cited as PW2 by the claimants in this case.
No, so far this case is concerned, there are several witnesses.
Yes, my lord, 20 witnesses.
But so far the claim case is concerned, only one witness.
One witness.
Only one.
It is sufficient, my lord.
Only one eyewitness.
Only eyewitness. And he was cited from the charge sheet. Eyewitness. My lord, thereafter your lordship kindly come.
আমি ওটা পড়ে নিতে পারছি,
আচ্ছা,
আপনি
ঠিক
বলুন।
আছে, তুমি বলবেন, আমি
হ্যাঁ।
এটা শেষ করে দিই।
ওটা বলবেন না, আমি শেষ করে দিই চার্জশিট থেকে, তারপর আপনি বলে নেবেন।
My lord,
Your Lordship, the ground of appeal, the insurance company has preferred the appeal on the ground that the offending vehicle was not involved in the accident. Your Lordship, first of all, our ground of appeal was on twofold, Your Lordship.
See, FIR name one vehicle, subsequently that is changed.
That's a different, we will come to the merit, but what is the conduct, what has happened in trial court? We have appealed in the trial court, we have not given an opportunity for doing the argument. Your Lordship, what we have, with our point, the first appeal ground is, we have not been given an opportunity for an argument in the case, where we have filed a time petition stating the fact the evidence has completed on 16th, and on 17th, the learned court has fixed it for argument and passed in judgment. We said, kindly give us 1 day or 2 day time to prepare the arguments, which has not been given to us. And for that reason, we have asked for remand back of the case, because we have the principle of natural justice has been violated. We cannot prove our case, we cannot argue our case properly, and the court has hurriedly passed in judgment in this case. Though many cases have been pending, but what is the hurriedness in this case, we are not aware of. And that's why we have preferred the appeal. This is the first round of appeal, Your Lordship. Next, Your Lordship, what has happened in this case, we have called for evidence by the IO. Wherein the IO has come before
you short time to argue, not evidence, not to adduce evidence.
We are coming. There's another point for argument also. Your Lordship, for evidence, we have called the IO. The IO came, but we have asked for the case diary. He has not brought the case diary. We have asked and he said, I can produce the same in a later date. But we didn't get an opportunity for again call him for with the case diary in this. Why the case diary is important, that I will show your lordship from the all the depositions and all, why the case diary has become important in this case. Your lordship, we should start with the firstly with the FIR. Your lordship, the FIR is on page 57, your lordship. It starts from page 55 and the FIR and the main FIR, the complaint starts at page 57, wherein your lordship will find in English it is written the vehicle number has been mentioned properly. That WB 34G 8130 or 8130. Your lordship, in the middle there's written in English. It's a Bengali written document, but in English it has been written. The vehicle number has been categorically mentioned. If your lordship permits, then I can. That সামনে একটি বেপরোয়া ট্রাকের চালকের ট্রাক্টর সোয়েন্সো নাম্বার থেকে অর্থাৎ মোটরসাইকেলকে ধাক্কা মারে এবং ধাক্কা মারার কোনো সৌগত তেওয়ারি গাড়ি থেকে পড়ে যায় এবং দারুণভাবে তার শারীরিক ক্ষতি হয়. Your lordship, this in FIR, it is the vehicle number is categorically mentioned and it's clearly been mentioned. Now, in this charge sheet, how it has been dealt with. The charge sheet, the main page of the charge sheet is page 64, your lordship. Page 64, second para, your lordship.
Page 64.
Second paragraph. During investigation, I have visited the PO, drew rough sketch map with explanatory index, examined available witness, and recorded their statement under section 161 CPC. On 20/12/19 morning, received email from Purbo Jadavpur PS and came to learn that injured Shogato Tiwari was admitted at Medica Super Specialty Hospital, Kolkata on 16/12/19 and expired on 20/12/19 at 55 hours over his injuries. During investigation, I came to learn from the complaint and witness as well as owner and driver of the offending vehicle that the original offending vehicle was WB 8Z7790 instead of vehicle number WB 348130, which was mentioned in the complaint. So, your lordship, here in one line, in IO has said, I have learned from the complaint as well as the witness and the owner that the vehicle number, the original vehicle involved in this case is not the number which has been mentioned in the complaint, but in a different vehicle with a different vehicle number. Now, why we have now? I'm just substanding why my argument, your lordship. My point of argument is why the case that is important, which we didn't get an opportunity, and the court has hurriedly done a judgment. Why I'm substituting why the case that is important. Now, your lordship, kindly come to the eyewitness, page 22. The whole case of the claimant is based on the eyewitness, your lordship, because no other evidence has been given by them. Your lordship, kindly come to the cross-examination. I have interrogated to the police. I have not received any summon from the court. I know that the claimants and I knew the deceased as neighbor. The accident occurred near so-and-so. At the relevant time, the deceased was riding his motorcycle. The offending vehicle was coming from opposite direction at the relevant time and dashed the motorcycle of the deceased. The motorcycle got badly damaged in the accident. The offending vehicle remained at the PO after the accident. After 15-20 minutes, the police came at the PO. The police took both the offending vehicles and the damaged motorcycle from the PO. So, your lordship, both the vehicles has been seized. The tractor as well as the motorcycle. So, the offending vehicle is the tractor and the victim was going on a motorcycle. Both has been seized as per to the deposition given by the.
Question is, seizure list was filed in court?
Yes.
So when was the date of seizure?
Your Lordship, কত পাতায় আছে সিজন লিস্টে?
Caesar, let us see.
Page 67, Your Lordship.
Caesar is 27/1/2020.
Yes. And there only they have put this vehicle.
No, 27/1/2020.
Yes.
Is the
Not the date of
Caesar.
Date of Caesar, Your Lordship.
Let us see the charge sheet. What he say? What is said?
He didn't say it. He said by the invest.
The date of Caesar, you see, is
Yes,
clearly reflected.
yes.
So cross-examination,
And the
the
date
date of Caesar is not that. Not at the time of incident.
Yes, and the date of it is should be the date of accident itself.
No.
But the date of Caesar is a different date.
Yes.
I understand, Your
Caesar is
Lordship.
a different date.
That's why we have said there is a collision has been there in the
Fact of
rounds of arguments. We have stated that point as well. Lordship, kindly come to the charge sheet is page 63, Your Lordship. Your Lordship, the facts of this case is that on 14/12/19 at 18:25 hours, Shalboni PS received a written complaint from one Subhash Chandra Tiwari, so and so, to the effect that on 13/12/19 at about 6 hours, his nephew, namely Shogato, 6 p.m., his nephew, namely Shogato Tiwari, son of Prabhas Chandra Tiwari, of same address, coming from Chandrakona Road to Shalboni, riding a motorcycle, number so and so, on the way Mondakupi, NH60, near Kali Mandir, one tractor WB 34G 81330 dashed his back. As a result, he received a grievous injury on his person. Local people shifted him to Shalboni Hospital. MO Shalboni Hospital referred him to the Mednipur MMCH and later on admit at Kolkata Medica Super Specialty Hospital for better treatment. Over the basis of written complaint, the above noted case has been started and I have endorsed the investigation of the case. Accordingly, I took up in the investigation. Your Lordship, the main portion of the Caesar starts from the end paragraph of this page only. Your Lordship, kindly come. We have already read up to this, the vehicle number which was mentioned in the complaint. I sent a prayer. This is written as Lordship. I sent prayer before the learned court for adducing section 304 IPC with the existing section of law. Learned court allowed my prayer. I served notice under section 133 MV Act to register owner of the offending tractor of 7790, namely Sheikh.
This notice served. This that is
to the offending vehicle 7790,
yes.
owner of the 7790, and Sheikh Kamaluddin
At the initial stage, this person was not. This person was injured, victim.
Is
injury case.
Yes, and then subsequently he died in Kolkata.
So just on the lodging of FIR, prior to the death, investigation was taken up.
It should have, Your Lordship, and as per to the
definitely.
eyewitness, yes, and as per to the eyewitness, Your Lordship, the case was the police was there and the police has took the custody of the vehicle from the.
No, but from the police report, it appears that on that
27/1 they have the main. I am coming to that, how the police has seized it, Your Lordship. Just 1-2 line left. With the direction to produce his vehicle and all connected papers as well as driving license of the offending driver. As per notice, he produces offending tractor number so and so along with all connected papers and offending driver's license. Accordingly, I seized the aforesaid offending truck with all valid papers as well as DL of the driver, with proper Caesar list duly signed by the witness and registered owner of the vehicle, and received the particulars of the accused driver, namely Shunil Bagh, the so-and-so address. So, Your Lordship, now the seizure list has come after the police has taken the investigation. After the complaint, the police has done the investigation. Police sent a notice and then they seized. But what the eyewitness is saying is a different story. So there lies the difference, and we want to harp on that there is a collusion, and which we couldn't argue and which we couldn't produce, which we couldn't adduce evidence also properly before the learned trial court. And there is no hurry to be decide in this matter what the learned trial court has done. And we want
see the lower court, the trial court records.
Yes.
So let me see the order sheet.
Yes, yes, yes.
Okay, first of all,
Yeah.
you see, learned trial judge has said heard the argument for both sides at length, but the written notes of arguments was not permitted to be filed. 16
We have
11
filed a
2000
time petition, Your Lordship.
16 no time petition. So you sought time to file the written notes of arguments. Okay, that was not allowed. So instead of written notes of arguments, oral arguments were heard, and this is on 16/11/2022. On the next day, the judgment was delivered. 17/11.
Your Lordship, kindly see the time petition, Your Lordship.
Yes.
The time petition will be there, Your Lordship. Your Lordship will see.
You see,
we have not done the oral argument as well.
the OP files a petition praying for time, filing written argument hard. Okay.
Your Lordship, kindly see that.
No, time was not allowed. So the petition was rejected. Heard the argument for both sides, not one side, both sides at length.
Your Lordship, we have not done the argument. That's the case.
You stated both sides at length.
So you'll kindly see the time petition, Lordship.
Maybe, but time petition is rejected.
Yes, that's why we have said
it is not an observation. Okay, suppose.
I understand, Your Lordship.
It is not an observation that heard so and so and fixed for judgment.
Yes, Your Lordship.
Both sides heard.
Yes, Your Lordship.
Yes, written arguments was not filed.
Because we need I have been instructed, Your Lordship.
So when was the, you see, 14/11. Okay, 14/11, you stated that you do not want to adduce further evidence. So OPW stands closed. So 16/11 was fixed for arguments. Anyway, now the question is you wanted to file written arguments. That was not granted. Instead, oral arguments were made.
Your Lordship,
so both sides at length.
What I'm summoning upon instruction, Your Lordship, we didn't get an opportunity to argue at all.
How is it that? Then you, on the very day, you could have filed a petition to expunge that, but not both sides, only one side.
Your Lordship, the time petition will speak for then.
Maybe after the judgment is passed. That review is there. If something is error on the apparent on the face of the record, you could have expunged. You see, this court sitting here cannot decide as to whether both of you heard or only one party heard.
But what is falling from the coordinate bench of this court, Your Lordship, the previous coordinate bench was hearing this type of matters. The coordinate bench has a view that the review petitions are not maintainable and you have to prefer an appeal.
No, you see,
the coordinate bench of this high court has been
very well, but these matter the Supreme Court held cannot be decided.
Yes.
Whether you are present and you made submissions and you are not
Yes,
present.
yes.
Okay.
And that's why that's a categorically we have made a ground for that in the appeal, your
Oh,
lordship.
no. This is Supreme Court has said these things cannot be decided in appeal. The remedy is review petition.
এখানে হয়েছে সেখানেই বলতে হবে হাইকোর্ট
সে তো কোঅর্ডিনেট বেঞ্চ allow
Court
করছে।
is stating this. How can I disbelieve?
Taking that also, your lordship, taking that also in mind, your lordship.
So you have to argue here at length.
Yes, yes.
If
Here,
necessary, you have to file written arguments here.
here it's not. I will show from your lordship how what is the conduct now. The how from the eyewitness they couldn't prove today ki the vehicle which was there in the as has been given as an offending vehicle was not present at the time of the accident. How? Because there are two contradictory statements, one in the charge sheet and one by the eyewitness. Something is not telling because the eyewitness is saying the vehicle has been seized by the
eyewitness. Contradictions appear.
Yes, then the lordship, their whole case is based on the eyewitness.
You can do one thing if you want. You can prepare some written notes, some argument, and argue in a summarized way on the next day.
Yes,
if you so
no
desire.
problem. No problem.
না তুমি শেষ করো তারপর রিটেন নোটস আর্গুমেন্ট ফাইল করে দেবো
ওরা বলছে
No, better
তারপরে করতে হবে।
both written as well as oral do simultaneously.
Yes, your lordship.
Yes, you have argued in part on the next day.
Yes, your lordship.
Yes, learned advocates for the parties are present. Hard learned advocates. Learned advocates are requested to come with written notes of arguments and make the submission on the next day. At a short date din to dekhe.
অনেক দিন হয়ে যাচ্ছে
12 May. আচ্ছা 12/5 হ্যাঁ 12/5/2026 কটা 10:30 at 10:30 AM.
এইটা হবে আর কাছাকাছি হবে 25th কিছু নেই
সেকেন্ড হাফে হবে কিনা দেখো না
ঠিক আছে 12 তারিখ বলছি তো
তাহলে এটা দেখে নাও সব কিছু আছে কিনা মানে দিস ইজ এই নামটা দিয়ে দিও হার্ডিং পার্ট yes actually this is my appeal on behalf of the injured claimants. My lord, in this case, what happened?
Is treated on the days list by consent of the parties and taken up for hearing along with this FMA. তারপর এই অর্ডারটা হ্যাঁ এই কারেক্ট নাম্বারটা দিতে হবে তাহলে যেটা কারেক্ট নাম্বার ওটাই ট্রিটেড ইন দ্য ডেজ লিস্ট আর এটা ভুল নাম্বার যেটা আছে তাহলে এটাকে তো করা যাবে না লেট ইট গো আউট অফ দ্য লিস্ট
Well, this is my appeal on behalf of the injured claimants. What happened, my lord? The injured was a driver of a police jeep. When, my lord, the police on one of the part of raiding party, he accompanied with the raiding party, driving the car on 28th February 2008 at about midnight. And my lord, after many searches and raid, when they reached at the spot, my lord, where the incident happened, at very early morning at 4 AM, At the nature's call, my lord, he left the vehicle and my lord, in front, well, the accident happened by one truck.
Yes.
Page 22 of the paper book, my lord, judgment.
And my lord, one of the police ASI, my lord, lost the complaint by the police station. Local police station lost the complaint, which was treated as FIR subsequently. My lord, the FIR number was written there just as WB11A 1664. 1664. Truck. WB11A 1664. It was truck. And he was shifted to hospital, different hospitals. And my lord, on the same day, my lord, he was ultimately admitted in CMRI Kolkata. After roaming different hospitals in the district, and ultimately, my lord, after few hours, my lord, he was admitted in CMRI Kolkata. He was treated there very few days. Head fracture and sustained injuries on head and different parts of the body. And my lord, in the meantime, my lord, and he paid his income as rupees 4,000 per month as driver. 32 years old, but he could not produce any disablement certificate at the time of trial.
Yes.
He could not produce any disablement certificate at the time of trial. During investigation, one of the IO of the police station, my lord, deputed conduct the investigation, my lord. He, my lord, from the different witnesses came under 161 statements. He came to learn that the vehicle number was actually WMK 1771 truck.
What is the award passed?
Award dismissed. Dismissed on 2 grounds: that he could not produce any disablement certificate, and second thing, my lord, the truck number as mentioned in the FIR and as mentioned in the charge sheet are different. That is why the learned tribunal dismissed the claim. In the charge sheet, my lord, the truck number is appearing as WMK 1771. My lord, kindly come.
37.
37, 34. In my lord, page 34, this is the written complaint.
Yes.
Then, my lord, in the written complaint, my lord, it is page 35, my lord. It is mentioned at the bottom. Have you also got it?
Yes.
Page 35. His written complaint is running on. From the bottom, my lord, 1, 2, 3, 4, 5, 6. 6 lines, my lord. সামনের দিকে হাঁটতে শুরু করে, সেই সময় আন্দাজ NH 15 তারিখ 28/2/2008 একটি ট্রাক পিছন দিক থেকে অত্যন্ত দ্রুত গতিতে এবং বেপরোয়াভাবে এসে উক্ত পাবলিক ড্রাইভারের পিছন দিকে ধাক্কা মারে এবং এবং তোমার অন্যদিকে পালিয়ে যায়, যাহার নাম্বার WB11A1664।
No, the claim case was against that FIR named driver or this charge sheet driver? Charge sheet named driver.
The police revealed within 2-3 days, my lord, that the one of the officer, deputed officer, lost the first information report. Not by any family members or friends, my lord, the initiated the lost the written complaint with the police officer. It is the case that the one police Chuomoto lost the complaint and to place the wrong number in the FIR. That is the manner simple case of the claim.
No, that SIR was in the vehicle.
Wrong number.
So complaint lodged by the police.
Police. Who was in the vehicle?
Who was?
In the vehicle at the time of accident.
Okay.
But after the accident, my lord, that vehicle was left away very fast.
Okay.
And it was very early morning.
So Tata Sumo.
No.
It is no FIR. It is stated.
So that Tata Sumo Jeep, my lord, that was the police raiding party was traveling.
Okay. Now, what is the nature of the vehicle?
Yes, for a truck. Both the vehicles, as mentioned in FIR and charge sheet, both are truck.
Both are truck. How about full auto?
Acha. My lord, dear after your losses, kindly come to page 37. This is charge sheet. My lord, page 38. The particulars of witnesses, number serial PW2 at the bottom, my lord. Dibakar Jana was cited as witness in the charge sheet. He was also came to witness box in the case, in this case, my lord, as witness of claimant. Thereafter, your lordships kindly come to page 39. Brief serial number 9, brief facts of the case. 17. Serial number 17. Page 39.
Yes.
My lord. The fact of the case is that on 28th February 2008 at about 11:15 hours, received a written complaint from ASI Shishir Kumar Mundu, who was engaged with raiding party duty on 27-28 February 2008 night with force and on vehicle number W1212 hired vehicle to the effect that at about 4:25 hours, the driver of hired vehicle named Sheikh Nazrul stopped the vehicle for attending nature's call. Suddenly, one truck bearing number WB11A1664, which was leading towards Kharagpur from Belda side, there's the side, said the Sheikh Nazrul from back side, and as a result, received heavy injury on the metal packed road, and the proceed truck disappeared in speed. The injured driver was taken to some nursing home. Later, he was taken to medical hospital, and at last, he was shifted to Kolkata Enhanced Hospital for better treatment. The incident occurred due to rash and negligent act done by the offending driver bearing number WP11A1664. Over this legal conflict started this case, I endorsed me. This case endorsed me for its investigation. In course of investigation, I read the PO draw the draft statements and its index and recorded the statements on the CRPC of found that the FIR named accused driver was not involved in this case. Engage source to find out the actual offense vehicle, the involved of the case. I also contacted of the FIR number WB11A1664. He stated in detail that his truck was not involved of same vehicle on that day, 28 February 2008 at 4:15 hours a.m. was not running under Narayanpur PS area. I was the son of Sheikh Anwar of Kasba and received his statement in WMK conference case whose owner resided at Kasba village after this contract is pursued, and he also stated the same after confirmation on raid and seize the conference and its papers under proper season duly signed by the driver of the same WMP 161 was surrendered before the last 10/8/2008 dated 10/9 10/9 and released on bail from the unexposed seized driving license of the driver Bahadur Dorji, son of Lok Bahadur of Tanzania, PS Kotwali, Islam, son of Fatal of Kazwa, and he told the name of the driver who made an on that day and type of the case. Then we also pass it from the learned court to the thief vehicle and his paper, and this is the case and the offending track number WMK 177 after obtaining proper list.
Now this Nojrul deposed as PW1.
Yes. Yes, madam.
So let us see his statements, PW1.
Page 12. Page 12. I am the petitioner claimant of the corruption case under defense and I divorce from them. I have filed this case for grant of compensation accountability trusted by myself on 28/2/2008 at about 4:35 hours. I stopped the vehicle number WV33 1212 Jeep as a driver on the left side portion of NI60 road near HON'BLE Beach for attending my research call, and at that time suddenly one of which was coming from the other side towards Karapur with high speed and dash on the driving by foot driver and dash me with great foot while the result I suffered all over my person and especially on my head, and I was taken to locally nursing home at Narayanpur, and therefore my admitted to the medical college hospital, and therefore my medical hospital was I admitted Calcutta Medical Research Institute, Kolkata, and my medical treatment is still going on. The accident took place due to reaction by the driver of the vehicle who drove the that violating the traffic rules. It is mentioned that the FIR registration number after the driver of the oxygen possibility for white Naranga PSS and charge sheet number 61 by 2008 under section IPC. Aforesaid charge sheet of the accident case has been accepted by the code of CGL proceedings. Immediately after accident, I was taken to nearest Lok nursing home at Narayana. Therefore, I was admitted in a medical college hospital and as an inpatient, and for deteriorated condition of my head injury, I was referred to NRS Medical College Hospital, Kolkata, and therefore I was further admitted and I treated there up to 11/3/2008 under Dr. in charge Dr. Sumit Rai, and after this still under medical still going on. Some of these 2 lakhs has already been cut towards on page 6 the time of accident he was 34. And at the time of accident, next page, I was driver of the vehicle number W.
Accident took place in which year?
2008.
2008.
At the time of accident, I was driver of vehicle number sir, and I used to get use of the department of the same sir, please. At the time of accident, the operating vehicle number W. And this is the evidence of PW1 claimant and my lord the cross is page 15.
Yes.
I am the claimant. I have submitted one affidavit. This is the affidavit. I know the contents. But this thereafter, we produce some documents which were exhibited and some documents which were marked as A3, and thereafter, it was ultimately by other witnesses, cross-examination by UP number 2 national. Presently, I am unable, but at the time of accident, I was a driver. On 28 to 2008. At that time, I was driving a Tata Suzuki number I stopped the vehicle after I cannot see any other occupants of my initially. Thereafter, I was admitted that treatment I have submitted. My lord, thereafter, my lord, the witness of PW2 Jana was eyewitness case, and my lord, he was also cited as eyewitness charge sheet also. I've already mentioned.
Yes.
Case 7. I see Divakar Jana Sama Rahul Chandra. Thereafter, on 28 to 2008, around 6 hours, I other police personnel and contacted or 121 as police personnel of Naranga PA and therefore say from by the time they could be Angla date or having once he was coming from by his driver and dash the driver usually on his day other police personnel were taken and he referred to therefore he referred to research and he going on. The accident it is mentioned 1664 as wrongly cross-examination to say the eyewitness. I have seen one motor vehicle accident in which I have found this code. I have filed one affidavit of my
No, this is PW2.
PW2. Continuing on page 19, cross-examination.
Yes, no, this is also cross-examination.
No, this is one.
Oh,
I have
that is.
submitted the chief of PW2.
Oh, it is not by way of affidavit.
Yeah, it was on the way of affidavit.
No, PW2.
Yes, madam.
Okay. Okay, this is affidavit in chief by affidavit.
Yes.
Okay, next.
Cross-examination by copy number 2 National Insurance Company. Presently, I am retired from service. In the last part of February 2008, I was posted at Narayangarh PS as constable. I know Shishir Kumar Mahata, ASI of police. At that time, Shishir Babu was also posted at Narayangarh PS. Shishir Babu was included in the party which was left PS for duty along with myself and other police personnel on the day. Date actually was 28 February 2008. The time of the accident was at 4:25 a.m. in the early morning. I knew Nazrul Islam as driver of a police vehicle. A complaint was submitted to Narayangarh PS in connection with this accident, and a specific case was started. ASI Shishir Kumar Mahato submitted the complaint. Shishir Kumar Mahato had seen the accident, how it had occurred. Shishir Babu in his complaint mentioned the number of the vehicle was the accident. But the fact that the vehicle once in has not caused the accident. But the fact Shishir Kumar Mahato had correctly mentioned the number of the vehicle which actually caused the accident in his FIR. Not the fact I am giving falsely at the register. Who is long appointed as driver of police vehicles. I discussed with IO Tishan regarding the number of the vehicles was mentioned in the to the IO for discussing with him. I know police has to record statement of witnesses to get the actual incident. I have not given any statement to the IO. Not the fact that I have falsely taken at the staff number W and moving towards collective site at a high speed at SCM. Not the fact that 11A1664 was what the FIR maker had disclosed to the IO when we have taken Nazrul Islam to locally nursing home for people. This is not the not the fact that it was possible to help Nazrul Islam to get the thereafter, Madam 2003 was the authorized vehicle of CMRI Kolkata. Okay. And Madam submitted some documents and treatment sheets and medical papers. Those were executed as Rule 5, Rule 6, and Rule 7. Thereafter, my lord, the judge.
The vehicle owner filed written statement.
No.
Vehicle owner did not contest.
No. Insurance company took leave under section 170 and thereafter they cross-examined, my lord, to eyewitness and claimant, both. They have not produced. My lord, in this case, the learned tribunal dismissed my claim since, my lord, the vehicle number is not tallying with FIR and charge sheet, not the same, identical. My lord, the insurance company, though took leave under section 170 of the Motor Vehicles Act. My lord, the insurance company failed to bring the owner and or driver of the offending vehicle as no witness to prove the vehicle in question was not actually involved in the accident. The 1664 was the first mentioned in the FIR. My lord, they could have called the owner and or driver of the said vehicle to prove that the subsequent vehicle which was introduced in the charge sheet was false, but they failed to do so. Thereafter, the insurance company failed to cross-examine the eyewitness to the extent that the offending vehicle, which was subsequently came to in the charge sheet was not at all involved in the accident, and the said witness is telling lie before the court. It was also not. Thereafter, my lord, the insurance company failed to produce any documents and also any one of eyewitness to prove that the offending vehicle was not actually involved and was far away from the place of occurrence. Insurance company also failed to cross-examine the IO, who was not in this case, my lord, no IO came. My lord, the learned tribunal, page 22. Judgment, my lord, very short, page judgment. On page judgment, my lord, page 23. Decision with reasons. Dismiss the case, my lord, on this one.
Page?
Page 23, 24.
23, yes.
23 and 24. Very short.
P1 and P2 are the eyewitnesses.
Yes, ma'am.
P3,
My lord, the claimant himself.
and P2 is the another eyewitness.
Another eyewitness.
And P3 is the
P3 is the from
hospital authority.
Hospital witness, my lord, to prove the hospital records and hospital bills.
Actually, you see, this person was on the road, not that he was sitting in the jeep.
No, on road.
On the road.
Nature's call, my lord.
On the road.
Yes, on the road. And the police party was in the jeep. So the number disclosed in the within few hours, my lord, it may be, my lord, wrong. Maybe.
No.
And the vehicle, my lord, after dashed him, my lord, left away the place.
So one of the occupant of the vehicle filed the complaint.
Filed the complaint with wrong number.
With wrong number or right number, that's a different issue. He filed the complaint. So on the basis of that complaint, investigation was taken up.
My lord,
During course of investigation,
yes,
the number was changed.
yes, my lord.
On whose deposition, on whose statement?
Yes, my lord, the investigation officer called the owner of that vehicle. He, my lord, stated in writing.
No, owner of which vehicle?
The vehicle mentioned in the FIR. He came to police station and my lord stated that his vehicle was not there on that date and time.
So let us see that again.
My lord, your lordship kindly come to page. Your lordship kindly come to page 40. 40 at the top.
Yes.
Have your lordship got it?
Yes.
In course of investigation, visited the PO, Dr. Rock sketch map and fix index, recorded the statements under section 161 CRPC of available witnesses and found that the FIA of W3111664 was not involved of this case. In case so to find out the actual offending vehicle who involved at this case, I also contact with the owner of the FIR named truck number WB111664 and he stated in detail that his truck was not involved of this case and the said vehicle on that date, that is 27/28/2008 at 4:15 hours AM was not running under Narangarh. I also examined the victim Sheikh Nazrul Islam and son of Sajan sir and recorded his statements under section where he told that offending truck number is WMK 1771 of this case. The owner deciding at first. My lord, he also, my lord, took some 161 statements of the available witnesses, my lord. Out of some, my lord, one witness came to witness box in the claim case as PW2, and my lord, he cited some witnesses as witness of occurrence and to prove the case before the criminal court. And my lord, in the charge sheet it is written, my lord, there are 9 witnesses in total, out of which my lord PW2 Divakar Jana also the same witness before both the in criminal court and in the tribunal also. Very peculiar, my lord, the number may be wrong in any circumstances, but it was, my lord, not on the hands of the raiding party, those who are waiting for the driver who on nature's call left the jeep, and my lord, some truck, my lord, dashed him and left away very rapidly from the place. My lord, it was not possible for the raiding party, those who are waiting in the jeep, and time, my lord, very vital, 4:25 a.m. in February. So it was night mode. So it was not possible for them to collect the number. So the vehicle, after dashing the people, my lord, left the place very
Question is,
rapidly.
you see, if the injured person or witness is unable to see the number, how they will say that this is
My
the
lord,
number?
other witnesses, my lord,
Other witnesses means?
the available witnesses from the spot.
Yes,
my
that
lord,
means somebody has to see.
Yes, my lord, somebody has to see.
Yes.
My lord, he was then and there, my lord, the claimant was taken to hospital in different hospitals within a day, my lord. So, my lord, the one of the officers on that, my lord, which, my lord, the investigation has been started. The police suo moto, my lord, started the case. So, in that case, in that situation, my lord, the vehicle number may be wrong. And thereafter, my lord, on the basis of the investigation, my lord, they find out, my lord, from the owner as described in the vehicle number in the FIR, my lord, the written statement filed by the owner of that vehicle, my lord, his vehicle was not on that area on that date and time. And on that basis, my lord, they search from the local sources that which vehicle may be. And my lord, ultimately found that vehicle. That owner has been called by notice. That vehicle owner produced all these, and my lord disclosed the driver's name. And he, my lord, the driver surrendered or my lord arrested by the IO. Filed, my lord, charge sheet on the ground of rash and negligent driving.
And you claimed how much?
My lord, in the claim application, my lord, there are only claim, my lord, 4 lakhs. My lord, peculiarity in this case, my lord, the claimant could not furnish the disablement certificate in the tribunal.
Anyway, that's
So,
a different issue, whether they, in the absence of disablement certificate,
I cannot claim.
what is the percentage of disability?
I do not know, my lord. Anyone do not
That
know.
cannot be.
So he, most probably he not examined by any board. That is, my lord, why I cannot claim the future loss of income, my lord. The what he expended in the hospital, and just proof that, my lord, the amount is 2,33,000 and odd.
601.
And my lord, the loss under pecuniary and non-pecuniary heads, which, my lord, in different judgments in different times by the apex court expressed in Arvind Mishra's judgment.
You see, here there is no question of pecuniary loss, you see, because it is not proved that you were disabled.
Yes, my lord, I am not on that, but some.
Only medical expense and pain and sufferings.
He was treated in the hospital.
Very well, but without any document, how the court will come to the conclusion?
Non-pecuniary, my lord, he can, my lord.
Non-pecuniary, yes, court has to consider the medical expense and pain and sufferings.
And my lord, the pecuniary, my lord, he lost some days in the hospital, my lord. At that point of he could not earn. And my lord, at the time of evidence, my lord, he is still claiming, and the witness is also claiming that he could not earn because he could not work.
Very well, that is for a particular period.
That we logically consider that. And my lord, the non-pecuniary, my lord, the expenses relating to treatment, hospitalization, medicines, transportation, nourishing food and miscellaneous expenditure, loss of earning during the period of treatment, future medical expenses, damage for pain, suffering and trauma as a consequence of the injuries, loss of expectation of life. All these are my lord. Your lordships kindly consider some amount on these heads and my lord the medical expenses which are proved by the claimant in this case, my lord. Only these, my lord.
Yes.
My lord, your lordship kindly come to page 19.
Page
19. The evidence of Divakar Jana, eyewitness.
Yes, of Dibakar Jana.
PW 3. 3 to, no 2, PW 2. My lord, last line, page 19, last line. A complaint was submitted to Narangarh PS in connection with this accident and a specific case was started. ASI Shishir Kumar Mahato submitted the complaint. Shishir Kumar Mahato had seen the accident. Shishir Babu had seen which vehicle caused the accident and how it had occurred. Shishir Babu in his complaint mentioned the number of the vehicle which caused the accident. I had no discussion with Shishir Babu regarding the number of the offending vehicle and manner of accident. And Shishir Babu lodged complaint and he mentioned the vehicle number WB11A. Some so and so.
So, has it come that this person did not see the vehicle number in cross-examination?
No. Next paragraph, my lord. Not a fact that vehicle number WMK 1771 truck has not caused the accident. Not a fact Shishir Kumar Mahato had correctly mentioned the number of the vehicle which actually caused the accident in his FIR. Not a fact I am deposing falsely and request of Nazrul Islam, who is long acquainted with me as a driver of police vehicle. I discussed with IOT Sen regarding the number of the vehicle which was mentioned in the FIR. Not a fact.
Oh, this is the person, okay,
Yes.
who claims himself to be eyewitness.
Yes.
And he stated that Shishir Babu lodged the complaint and the number.
No.
So this person did not lodge the complaint.
No.
Yes.
Therefore, it was not proved, my lord, that this vehicle was truly involved in the accident.
So where this person has stated that he has disclosed the correct number to the IO, which paragraph?
No, my lord, this is another matter, previous matter.
No, you see, PW2, this is PW2.
Yes.
There is a suggestion that
Yes.
not a fact, I have falsely stated that I disclosed the correct vehicle number to the IO for discussion with him. So did this person state that I have given the IO the correct number in his chief?
No.
My lord, he was examined under section 161 CRPC.
So he is cited as a witness.
Yes, my lord. In the charge sheet also. Not here, my lord. Not only here. He also cited as
I
charge
know
sheet.
police has to record statement.
And my lord, your lordship knows that this is the settled principle of law that FIR and the averment in the FIR not the sacrosanct. So if there is some wrong, that can be curated during course of
No,
investigation.
question is regarding this number. Okay, he in cross-examination, he stated that I have not given any statement to the IO, but he is cited as a witness.
Yes, even my lord in the charge sheet also.
Yes, no, charge sheet I'm saying.
Yes, my lord. And my lord, accident happened in 2008. He is on the witness box in 2014, after 6 years, my lord.
Okay, in charge sheet, let us see what the police said, that this vehicle is wrong.
Yes, sir.
Charge sheet.
Charge sheet, page 40. Page 40, I have already shown, my lord. From the
Yes.
top. In course of
Victim Nazrul Islam, Sheikh Anwar Ali, Nazrul Islam, and this. Sheikh Anwar Ali. Anwar Ali is this eyewitness.
No.
No.
Anwar Ali is the father of Najrul.
So he was not there on the spot, but he stated the offending truck is WMK 1771.
You will not see. Only come to page 40. I also examined the Nazrul Islam, that is the victim here, and this
Oh, only Nazrul Islam.
Islam, where it told the offending truck number is such and such, the new number of this case, whose owner decided after this contract. So he also stated the same after confirmation, since the offending victim such and such, and its papers and the proper signature duly signed by the witness and the driver of the same of WMK 177 surrender before the line court. On 10/9/2008, I released on and he say that he line court is driving I also issued one copy and you the number on that day, the time of this case. The driver knows, the owner knows his driver met with accident on that date and time. And on that effect, my lord, the written instructions filed with the officer, conducting officer, and my lord, it was part of the case diary.
Yes, next.
My lord, this is
I already submitted, my lord, with humble submission, my lord. The insurance company, my lord, in this case, no, failed to produce any eyewitness who can told their favor. And my lord, they failed to produce the
my lord, it was
driver
not
and
possible
owner of the driver and owner of
for
the
the insurance company.
truck mentioned in the FIR to culminate the actual position.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. Hearing is concluded. Let this matter appear on 11/5/2026 for judgment.
Well, I prepared some short notes, my lord.
Yes. Let the short notes prepared, filed, be kept with the record. নাকি 12টার সময় একটা ফিক্সড ম্যাটার ছিল নাকি? কল করে দিন দেখি কি আছে কিনা বোথ পার্টি।
Lordship, my matter is fixed at 12, item number 5.
Yes.
5 and 6, Your Lordship. Lordship, learned advocate for the appellant, Mr. Shanti Shatra, has not found out.
So
Most probably, sir.
anyway, let it be not this week. Oh, anyway, some other date will be fixed.
Your Lordship, already, Your Lordship wanted to submit, Your Lordship. There are 2 appeals connected with the same
Yes.
accident. Your Lordship already disposed of 1 appeal. So same points also can.
No, which appeal I have disposed?
Your Lordship, judgment আছে না? That matter, Your Lordship, was disposed of just
Anyway, I'll hear out. You come with the short notes.
Your Lordship.
Yes, learned advocate for the respondent in FMA 436 of 2024 is present. As none appears for the appellant, let this matter stand adjourned till দেখুন তো
What date, Your Lordship?
কবে? 14/5/2026 at 12 p.m.
Lordship.
Well, matter was mentioned start the matter 27 fixed for execution. Matter the file is sent tomorrow. Yes, start the
এই
matter.
ওটা দেখুন, ওটা যদি থাকে ফাইলটা তাহলে ওটাকে
File is
হ্যাঁ যাকে সোমবারে এসে দেখে দেবেন। When is the next date fixed?
27.
20?
সোমবার Monday.
হ্যাঁ 27 তারিখে এটাকে ইয়ে করে দিন, তুলে দিন, একটু দেখুন আর কি, বা কোনো কাউকে দিয়ে একটু চাইয়ে নিন আর কি, এই ফাইলটার জন্য আর কি। এই হ্যাঁ
আগেরটা
কত তারিখে
তুই দিকে চলে আয়, তুই দিকে চলে আয়।
Yes, hence this appeal FMA 64 of 2025 stands disposed. The judgment and award dated 11/9/2024 passed by learned District Judge Nodia in MSC case number 370 of 2016 stands modified to the extent that the appellant's claimants are entitled to rupees 10 lakh from respondent number 1 SBI General Insurance Company Limited. The respondent number 1 shall deposit before Registrar General High Court Calcutta rupees 10 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is paid, the balance amount be deposited. The appellants will be entitled to withdraw the compensation upon compliance of necessary formalities.
Extremely grateful to my lord. We are obliged.
Fixed matter. Item 7, you are for the appellant. So some other date has to be fixed.
Fix it on 7th of May.
দেখুন 7th of May তে 10:30টায় দেওয়া যায় কিনা। 7th May 3টের সময়। 7th May 3টের সময়। তারপরে তার আগে কি পড়ে? Yes. Learned advocate for the appellant is present. None appears for the respondent. Let this matter appear on Friday. Actually, some original side matters are taken up. There is uncertainty. Some part-out matters are taken up. 15th is Friday. Friday. Yes. So other than Friday, if you can suggest something, 14th or 18th. Okay, 14. দেখুন 14 তারিখে আছে? 14/5/2026 at 3 p.m. No matter both sides. Yes, there are no matters, but both sides are present.